Legal implications of software development. Unisys versus RACV. The Royal Automobile Club of Victoria, that is to say the RACV, sued IT solutions company Unisys because they failed to deliver a product. A bit of backstory there. RACV is an insurance company. They, in the early to mid-90s, were processing about 70,000 insurance claims per year, which involved about 1 million sheets of paper. And this was all being done manually, page by page. They wanted a workflow management system that could store and retrieve the information and scan lots of paper documents and retrieve them within 2 to 4 seconds. The system that RACV delivered took between 20 and 40 seconds to return a scanned document. RACV sought to reform its workflow procedure to produce faster and more efficient handling of claims, cost saving, and therefore client satisfaction. Unisys were engaged and agreed to deliver a system that would produce the document on screen in 2 to 4 seconds and failed to deliver that promise. The key representations by Unisys, there was no commitment to any particular configuration. RACV says that's a lie. RACV said the system didn't fulfill its requirements, imaging access in near-line claims with a response time of 20 seconds, but they were taking up to a minute. The judges agreed that the requirements of adequacy storage capacity for RACV to quickly retrieve documents was critical. In particular, Unisys had represented that the system would provide high-speed image access for online claims with retrieval times approximately 2 to 4 seconds and a maximum image access in near-line claims with expected responses times of 20 seconds maximum. The judge accepted that the system did not perform in accordance with these representations and ruled the case in favour of the RACV. Judge Hanson found that the alleged representations had been made and RACV was induced to entering the contract because of such representations, which were in fact misleading and deceptive. Judge Hanson ruled in favour of RACV and Unisys was sued for more than $4 million. Judge Hanson further held that insofar as the representations were to future matters, Unisys had no reasonable grounds for making them. The case brings about an interesting precedent for software developers and IT service firms, which now further risk litigation if they fail to deliver on promises to clients. The result clearly demonstrates that companies should not be scared to face up to the computer industry and say that it's not good enough. Section 52 of the Trade Practices Act deals with the misleading and deceptive conduct which was the basis of the RACV insurance claim. Unisys made deceiving and misleading claims. Changes were made to this section, which also influenced the legal relationship between customers and IT suppliers. This case set an example for the suppliers of IT systems that pre-contractual negotiations should take great care to avoid any false or misleading representation in relation to features or benefits of their IT systems.